Welcome back. In this video, or series of videos, we'll be taking a look at the material from Chapter 12. As we go through Chapter 12, we'll take a look at the agreement, which is the first element of a contract, and we'll find out it's comprised of an offer and acceptance. One thing that I didn't do in the first video is something that I normally would do in a face-to-face class. Those of you who've had me in class before, you know that I usually start each class period with what I call the lawyer joke of the day. Being a lawyer, my friends and family think it's funny to send me all the lawyer jokes that are floating around out there and on the internet and places, and so I have quite a collection. And so normally I start out class with the lawyer joke of the day. Well, in this class I intend to post these videos one chapter at a time, which is approximately once a week. So I think what I'll do is start out each video with the lawyer joke of the week. And the first one goes like this. There was a lawyer who had just won a big case, and he had a lot of fees coming his way, a lot of money, and so he decided that he would treat himself, and he would celebrate a little bit by buying himself a brand new car. He never had a new car before, so he went down to the car dealership and bought a brand new BMW, $75,000 car. And he was pretty proud of it. He was driving it home and checking out all the features in the car, and wasn't watching the road quite as closely as he should have been, and he ran the car off of the road and into a tree. And it was a pretty bad crash. He wrapped the car around the tree, and it threw him out of the car and into the ditch and knocked him unconscious. It just so happened that there was a sheriff deputy who was following him and saw the crash, so he pulled over into the ditch to see if he could help. He saw the lawyer there in the ditch unconscious, and he actually recognized him as a lawyer from being around the courthouse and such. And so he went over to the lawyer and kind of tried to shake him to revive him. And it worked, and the lawyer came to and opened his eyes, and the first thing the lawyer saw was his brand new car, and it was completely totaled, wrapped around the tree. And the deputy said, "How are you?" And the lawyer said, "Oh, I'm terrible. Look at my car. I can't believe this. I haven't even gotten this car home one time, and now it's completely totaled. I can't believe this is terrible." And the deputy said, "No, I mean you. How are you feeling?" And the lawyer said, "I feel terrible. I mean, look at my car. I can't believe this is a $75,000 car. I can't believe it's totaled, and I can't even use it at all." And the deputy was a little perturbed by this. He says, "You know, you lawyers are all the same." He says, "All you care about is your money and your material possessions." He said, "You didn't even notice that in the accident you lost your left arm. Your left arm was severed at the shoulder." Sure enough, the lawyer looked down and he saw that his left arm was missing. He looked back at the deputy and said, "My Rolex." And that's about the same reaction I get in class when I tell that joke. It's complete silence. Anyway, let's get on with the material here in Chapter 12. As I mentioned, we're going to be talking about the agreement, which is the first element of a contract. If you remember from the last chapter, I told you that there are four basic elements to a contract. How do we know if a contract exists? If the four elements are present. What are those four elements? Agreement, consideration, legality, and capacity. In these next chapters, we're going to be taking a look at each one of those elements in a little more detail. The first one we're going to be looking at is agreement. How do we know if the parties have formed an agreement? Well, courts have used the language that's on the slide here, actually. They've determined that an agreement is where the parties have a meeting of the minds. It says the parties may contract only if they have a meeting of the minds. The parties, in other words, intend to form an agreement, and they have mutually assented to the same terms of a bargain. Courts, in determining whether the parties have formed an agreement, will use what we call the objective theory of contracts. In other words, how does a court determine whether a party intended to form an agreement or didn't truly have that intent? Courts use the objective standard or the objective test, which is to say, they will look at what a party does, what a party says, and the context in which they do and say it to determine a person's intent. If a party talks like they have a true intent to form a contract, they act like they have the true intent, and the context indicates that they are serious, then a court will determine that they do have the intent to form an agreement. Even if secretly in their mind they don't subjectively have that intent, a court looks at the outward expression of a person to determine their intent. Well, in order to have an agreement, the courts say that an agreement is comprised of two parts, an offer and an acceptance. If we have a valid legal offer and that offer is accepted, then we have formed an agreement. So the natural first question is, how do we know if we have a valid legal offer? So let's start with offers and talking about offers. First of all, I want to mention an offer in contracts is a powerful thing. When a person makes an offer, it creates in the offeree, the one receiving the offer, something called the power of acceptance. And what I mean by that is this. Once I make a valid legal offer to you, and it meets the elements of a valid legal offer, which we'll go over in a second, once I propose that valid legal offer, all you have to do is exercise your power of acceptance and accept that offer, and now we're bound, and we've formed an agreement. And assuming we have all the other elements of a contract present, then we've formed a contract which a court will enforce. So how do we know if we've made a valid offer? Well, an offer is usually comprised of three elements, and they're listed on the slide. How do we determine if there's an offer? First, did the offeror intend to make a bargain? In other words, was the offeror objectively serious? Right? Was this a serious offer? And did the offeror intend to be bound by what it is they're promising? If not, then it's not a valid legal offer. Sometimes parties say things and make offers which are obviously made in jest or anger or in some sort of undue excitement that indicate that the party's not serious. For instance, I have an example of this. Let's assume that I have a car. This is, by the way, not a hypothetical situation. When I was in high school and college, my early college years, I had a car which was a 1972 Volkswagen Beetle. And the last 3 years I owned the car, it did not start under its own power, like with a key, like most cars start. Luckily, it was a 4-speed, and so every time for the last 3 years that I owned the car, I had to start it by opening the door, running, pushing the car, jumping in the car, popping out the clutch, and starting the engine that way every time for 3 years. Needless to say, I got tired of doing this. Right? So let's say that one day you're with me, and for the millionth time, I try to start my car with the key, and it doesn't start. So I get out of the car, and I slam the door, and I kick the tire, and I say, man, I'm so angry at this car. I'll sell you this car for $1. What if you say, I accept? Am I bound to sell you my car for $1? I mean, under those circumstances, was I objectively serious that I truly intended to be bound to my promise to sell you my car for $1? Well, probably not. A court would look at that and say, objectively, the circumstances were such that it was clear that I made that offer in anger or in jest, and I didn't truly exhibit an intent to be bound. So that, in that circumstance, would not be considered a valid legal offer. The second element to a valid legal offer are the terms defined. Are the terms of the offer definite? So this part of an offer would eliminate an offer that's made this way. If I came up to you and said, hey, I offer to do something for you sometime for some money, okay? Could you accept that? Is that a valid legal offer? Well, no, the terms aren't definite enough. What am I promising to do? For whom? For how much? In what time frame? The terms of the offer are not definite. And so a court would have a hard time determining that that was a valid legal offer. You'll notice on the slide I've made reference to Bear versus Chase, which is kind of a famous, maybe an infamous case now about the television show The Sopranos and how it was created. Go read that case in the materials, and it serves as an example of a situation where a party's offer was not definite enough for the court to enforce. Last, in terms of a valid legal offer, the last element is, was the offer communicated by the offeror to the offeree? So in order to have a valid legal offer, it must be communicated to the offeree. If I came to you and I offered to sell you my bicycle for $50, and you were looking at the bicycle and you said, well, I'm not really sure. Can I have some time to think about this? And I say, yeah, you can take your time. You have till Saturday, and my offer stands. It's good until Saturday. So you go home, and you're not sure you want to buy the bike, but you tell your roommate about the bike. And your roommate is very interested in the bike. In fact, your roommate says, you know, can I have Hunt's number? I want to call and accept that offer right now. $50 is a great price. And so your roommate calls, and I pick up the phone, and your roommate says, I accept. I accept your offer. of the bicycle for $50. Am I bound to sell the bicycle to your roommate for $50? Technically, no, because the offer was not communicated to your roommate. It wasn't communicated to that offeree. I communicated it to you. Now, as a practical matter, if I was willing to sell you my bicycle for $50, I'm probably willing to sell it to your roommate, but I'm not bound because that's not a valid legal offer made to your roommate. It must be communicated to the offeree. Okay, next let's take a look at some problems that come up, especially with the intent part of an offer. And like I mentioned, sometimes it's difficult to determine if the offeror is objectively serious in their offer. And what I've listed on the slide here is some activity that's typically not considered an offer. As we go through this, I'll give you some examples, and they will sound very much like offers in terms of the way we really talk about things. But there's a problem with them, and I'll go through that. First, let's take a look at invitations to bargain. If I come to you and I make you an offer that says, I will not sell you my motorcycle for less than $500, and you say, I accept, did we just create an agreement there? The answer is probably no, because what I'm telling you is I will not accept less than a certain amount, not I offer to sell you my motorcycle right now for $500. That would exhibit a present intent to be bound. But when I make the statement, I will not take less than a certain amount, really all I'm doing is stating my future intention, right? Or making an invitation for you to bargain with me. In other words, I'm saying to you, make me an offer of more than $500. But my statement of I won't take less than $500 is not a valid legal offer capable of being accepted because it's simply an invitation to bargain. Similarly, any kind of statement of intention or future intention isn't an offer because it doesn't exhibit a present intent to be bound by what I'm promising, and that's what an offer requires. So if I say, I plan on selling my motorcycle for $500, and you say, I accept. Again, we have a problem because I haven't made a valid legal offer. There's a problem with a future intention there. I'm simply stating to you, I plan at some point in the future to sell my motorcycle for $500, not necessarily to you right now. And so when we parse out the words, it looks like that's simply a statement of my future intention. What about letters of intent? Businesses do this from time to time. And one business, for instance, will write a letter of intent to another business. And they'll say something like, it is our intention to form an agreement with you to buy a certain number of your products at a certain price over a certain period of time. And the question that comes up a lot of times when we use these letters of intent is, well, is this a valid legal offer? The recipient of this letter of intent, could they simply reply back, I accept, and now we have an agreement? Or is this simply just a statement of future intention? It's our intention at some point in the future to maybe agree with you for these things. Well, unfortunately, I can't give you a black and white answer on that. I'll have to give you what I call the lawyer's answer on this. It depends. It depends on the language of the letter of intent. The closer the language of the letter intent gets to exhibiting a present intent to be bound by a certain promise, then the closer we get to a valid legal offer. So in these cases of letters of intent, we're kind of stuck with just looking at the facts of each case and the language of each letter to determine if it's capable of being accepted as an offer. Next on our list here we have advertisements, and this is going to be maybe a little confusing to some of you right off the bat because we don't normally think of advertisements this way. But I will say this, the general rule is an advertisement by itself is typically not a valid legal offer capable of being accepted. What we legally consider advertisements as are solicitations for offers. Okay, so my example, let's say I have I received the newspaper, the shopper in the mail that has all of the flyers and advertisements in it, and I get an advertisement for local furniture store, and the advertisement says a certain brand of leather couch for $500, and I think I need a leather couch and $500 is a good price, so I tear out the ad and I go down to the furniture store and I walk in the door and wave the advertisement in the air and say I accept. So have I created an agreement with the furniture store to buy that leather couch for $500? Technically, no, because an advertisement by itself is not a valid legal offer capable of being accepted. It's actually a solicitation for me to come down to the furniture store and make them an offer to pay $500 for that particular couch. And the problem is with this. An advertisement doesn't exhibit a present intent to be bound by the specific terms of the advertisement, because what if all 2,000 people that received that advertisement walked in the door at the same time and they all said, "I accept," and the furniture store only had 5 couches in inventory? Would they be bound on 2,000 other or 1,995 other contracts that they couldn't perform on and then therefore breach? No, the law gives them a little leeway, and so we don't typically consider advertisements by themselves valid legal offers. Now, one thing that may confuse you a little bit, and does confuse students a lot, is this idea that, well, a furniture store, for instance, can't advertise a leather couch at one price and then refuse to sell it to you at that price when you go down to the store and require a higher price. They can't do that, right? And the answer is no, they can't do that. But it's not because of contract law. It's because of another law, a statute about false advertising, right? So there's another law at play that says you can't advertise a product at one price and then only sell it for a higher price, because that violates the false advertising statute. But whether it creates a contract is a different legal issue. Okay, and last down here on our list are auctions. Auctions, when I put an item up for bid at auction, and I'm the seller, and I say I'm going to sell this item at auction, that in itself is not the offer. In other words, when you go to an auction and the participants bid and make their bids of higher prices, those aren't the acceptances of the offer. The bids at an auction are the offers, which then the seller can either accept or reject. So think of it this way: when you go to an auction and the participants are bidding higher and higher, what they're really doing is they're making higher and higher offers, which the seller then can either accept or reject. Now, unless specifically stated, auctions are conducted without reserve, which means the seller reserves the right to accept or reject any of the offers that are made. In fact, if you go to certain online auction houses, eBay for instance, and the auction is conducted without reserve, what that means is there's no price at which the seller won't sell. Anyway, auctions, think of them this way in terms of offers. Auctions are solicitations for offers, and the bids are typically the offers.